From California to New York, from Amsterdam to the Caribbean, from Kansas City to Washington, D.C. In courtrooms, in classrooms, in conference rooms, and in webinars. Every day people gather at ABI events to hear the best ideas bubbling up in their communities. Today, you are a part of a global conversation about our shared future. So, what is this ABI Talks? ABI Talks is an initiative of the ABI Board of Directors Education Committee, a committee devoted to creating the best and most exciting bankruptcy education possible. The committee plans and organizes this conference and the annual spring meeting in Washington, D.C., and helps set policy for regional conferences. This event today is based on the TED Talks format and ideals, but is independently organized by the ABI. So please be sure to thank the team of volunteers and ABI staff members who worked so hard on today's event. It is their ideas, dedication, and time that makes this all possible. The views you hear today are, of course, the views of those speakers, not necessarily of the ABI. We hope their talks spark an exciting conversation among you. It is a day for curiosity and skepticism, for openness and for critical thinking, for inspiration and for action. The more you enter into it, the more you will take out. And now, on with the show.
Good morning again. I have the pleasure of being your Master of Ceremonies for today's ABI Talks program. Today you will experience some of the best ideas and lessons bubbling up from the bankruptcy community, all presented by 5 of your fellow ABI members. Our program, of course, is based on TED Talks. TED is an acronym for Technology, Entertainment, and Design, and these are the fields of experience around which the first TED was conducted in 1984. Since then, the TED program has become a globally recognized format. The ABI Talks program, of course, is younger, started in Terranea a few years ago, and that format has been copied at numerous regional conferences. Our speakers were selected today because of their special expertise in areas that we thought might be of interest to you. As we have in the past, we selected 2 programs from recent regional conferences. We were so impressed, we wanted to share these presentations with a national program audience. The remaining 3 are brand new. One important note on the format: unlike many of our other formats, we would appreciate that if questions percolate during today's presentations, you hold it until after the program. Our speakers will gladly meet with you in the hallway after the presentation. And now, on to the show. Our third speaker joins us from the Windy City. There he is a partner at Jenner Block who practices business bankruptcy law. But he also has a side job. He's a consumer bankruptcy expert. In addition to his numerous other accomplishments, he is currently a member of ABI's Commission on Consumer Bankruptcy. Ladies and gentlemen, ABI Talks is proud to present Ronald Peterson.
Only my late mother called me Ronald, and only when she was very, very angry. Gertrude Stein said in her poem, Sacred Emily, "A rose is a rose is a rose. By any other name, a rose." In 1922, in her anthology, Geography and Plays, someone asked her what she meant. And she said, things are what things are. A is A is not B. Thinking about that, I raised the question, what is a transfer? Is a transfer a transfer a transfer, or is it something else? The code in section 101 defines transfer to include each mode direct or indirect, absolute or conditional, voluntary or involuntary of disposing or parting of an asset, property, or an interest in property. We're going to explore today the approach of 4 different courts, not all consistent. As I do that, Look at how these courts decided the question, for each of them chose a different path. Our first case, the one that started it all, was Bonded Financial versus European American Bank. This case involved the life and times of Michael Ryan, who operated some 45 currency exchanges in the city of Chicago. In 1983, as his financial empire was collapsing, he directed one of his currency exchanges, Bonded, to send a check to his personal bank account at the European National Bank, or European American Bank, for $200,000. The check had a note on it that said, deposit it in Michael Ryan's account, which the bank did. The problem the trustee faced was that Ryan was not a target of opportunity. The US government had already caught him, and he was now the permanent guest of a gated community operated by the US Department of Justice. So he sued the bank. This matter got up to Judge Easterbrook in the Seventh Circuit, and in a very scholarly opinion, Judge Easterbrook said, if the memo line of the check had said, pay off the horse loan, this would be an easy fraudulent transfer case. But since it said just make a deposit, there was no transfer. He adopted a rule that said that the bank has to have dominion and control over the funds that were deposited before there can be a transfer. Now, what does a bank do? We learn in 101 banking and economics that when you deposit money in a bank, all you're doing is getting in return a claim against the general assets of the bank. Not only that, but Bonded was not the bank's customer. Ryan was. How could Bonded demand a return of the account? It could not. Why did Judge Easterbrook reach this conclusion? He noted in his opinion he was concerned that if he said that a deposit into a bank was a transfer, there were tens of millions of dollars of deposits per day in the United States that could be potentially avoidable. And I'm sure in the last 20 years that number has grown exponentially. And therefore he adopted this rule to protect banks from suits by trustees for deposits. The next matter came up in Ivy versus First Citizens Bank. This involved the nefarious activities of Mr. Whitley, who, like Mr. Ryan, ultimately wound up as a resident of the Gray Bar Hotel. In the meantime, the relentless trustee sued the bank to recover almost $2 million in deposits that the bank had received during the course of this mini Ponzi scheme. The trustee, not surprisingly, lost in both the trial court and the district court. Both courts took the position that fraudulent transfers are really a statutory tort. And because when you put money in a bank, you're getting back a claim against the general assets of the bank, the estate remains in a sort of economic neutral buoyancy. Therefore, like basketball, no harm, no foul. When the matter got up to the Fourth Circuit, and the parties hadn't briefed the question, the court ruled not only was there no fraudulent transfer, there was no transfer at all. Unlike Judge Easterbrook's approach, though, Judge Gregory said, we look back at precedent. In 1930, under the Act of 1898 in the Lineberger case, we said that a deposit in a bank was not a transfer. And we based this on a 1904 decision of the US Supreme Court known as New York City National Bank versus Massey. Now, what the Massey court said was that when the debtor, in that case, deposited money in a bank, he received back a claim against the general assets of the bank. There was neutral balance, buoyancy, and therefore there was no transfer. They read that decision for the proposition that deposits into a bank are not a transfer. Now, it is important and a great lesson to be learned that as we do research, we ought to look at these ancient Supreme Court cases. Professor Klee has given this body a lecture on 19th century bankruptcy cases in the Supreme Court and how they would affect us today. I just recently had a case where I thought we had a big winner until my opponent came up with an 80-year-old US Supreme Court case that sort of supported his position. Again, I'd rather go in the court saying I got a Supreme Court decision on all fours. It's harder to stand up and say, well, I'd like to distinguish this case. But again, the Ivy court had no problem striking this down, saying there was no transfer. Now my favorite case, Maloney versus Huntington National Bank. This involved an artful guy by the name of Baron Watson. And like double jeopardy, the scores in this case are really going to add up. He had two companies, Serbico and Teleservice. He told the bank when he opened the line of credit that Teleservice sold computers to Serbico, and Serbico in turn sold these computers to the public. What he thought the bank didn't need to know was that Teleservices had no business. It had no employees. All the officers and directors of Serbico changed their names to fictitious names and filled out the papers with the state of Michigan to create a fake teleservice. Things went on for a number of years, and then one bright, sad day, Teleservices bounced a 7-figure check to the bank. The bank officers all trumped out to Michigan to see what was going on, and Watson explained, well, Teleservice is a startup company that had pushed millions of dollars through their bank, and they were a factor. They collected the receivables for Serbico. They didn't supply Serbico with computers. Now, the bank's files indicated what the original set of facts were. Nobody at the bank bothered to read the old files to discover that Watson had changed his story. By January of 2004, they demanded a lockbox, which Watson refused. They then looked at his accounts receivable reports and found out that a lot of the customers did lockbox transactions all the time. They even found some of the customers were arch competitors of Serbico. Why are they customers of Serbico? And so in April of 2004, a bank officer named Kelb asked his security department to run Mr. Watson. I know you won't believe this when I tell you that he was a 2-time convicted felon for bank fraud, had served time in a big tall house, had been disqualified as a broker by the NSA-DM. Now, did the bank pull the plug? No, because Kelb didn't tell anybody of what he found. Finally, in July of 2004, the loan was paid off, and there's a 1-word email from the bank officer. Whew. The matter went up to the Court of Appeals, and the Court of Appeals followed the precedent of the Seventh Circuit and said that the bank, with respect to deposits that were not used to pay down secured loans, were not avoidable because there was no dominion and control. Oddly enough, Judge Rogers in his decision defines control and dominion as being able to put the money to your own use. Isn't that what banks do? Don't banks take it and lend it out, have Christmas parties for the employees, and buy the president of the bank a Maserati? Isn't this just a fiction? Finally, we have the third case in the trilogy, Shainman versus the Bank of the West, also known as the Tenderloin Healthcare case. Now, the case has some really complicated facts. We deal with the topic of whether you can have a double hypothetical test to avoid a preference. I'm not going to go there because it would take another TED Talk, but the final point that they raised was that there was no transfer. This was the bank's defense. And they cited Ivey and they cited Maloney and said we should win. For the first time in any of this trilogy, the Court of Appeals for the Ninth Circuit said, let's look at the legislative history. And when you look at the House report, and when you look at the Senate report, the first thing they tell you is that transfer includes transfer of possession. When I deposit money in the bank, I'm giving up possession. But more importantly, both reports that came out in 1977 state that a deposit in a bank account or a similar account is a transfer. Now, there was petitions for cert filed in the Ivey case, which was denied. And there's one other case that the Court of Appeals in the Ninth Circuit wrestled with this spring called Henry versus the Official Committee of Unsecured Creditors and Wall Design, where the Ninth Circuit wrestles with this question of what is a transfer. And they draw a distinction between a dominion and control. And so when I looked up in my Webster's dictionary the definition of dominion, it told me that dominion is control. So we are left with this sort of conundrum. What I want to point out here is that the issue, which now the Supreme Court has denied cert twice, needs to be resolved by the Supreme Court. How can you have a transfer without a transferee? Shouldn't we look at fraudulent transfers as a statutory tort and look to see if the transfer caused any damages? Did the district court in Ivy get it right? Because if we don't, then the question will be that while a rose is a rose is a rose, is a transfer really a transfer? Thank you.